Hello guys, welcome back to my channel Ajay Sharma Law. So today we are talking about a very important case law that changed things for a lot of workers. Bangalore Water Supply and Sewerage Board versus Rajappa. So let's start to the discussion on that. Bangalore Water Supply and Sewerage Board versus Rajappa, 1978. Facts of this case. The Bangalore Water Supply Board was a government statutory body that imposed a fine on its employees. The employees challenged this action in the Labour Court seeking relief under the Industrial Dispute Act 1947. The Bangalore Water Supply Sewerage Board argued that as a public utility and a statutory body, it was not an industry, and therefore the Labour Court had no jurisdiction. So the problem was that the Bangalore Water Supply and Sewerage Board is a government group that provides the water. They had a problem with some of their employees and took action against them. The employees went to the court and fined back. But the Bangalore Water Supply said that we are a government group, not a business. So the Industrial Dispute Act applies on the industry or a business. It does not apply to us. The court shouldn't hear this case if Bangalore Water Supply Board was right. All of its employees would loses their legal rights under that law. But a 7 judges bench of the Honorable Supreme Court rejected this narrow interpretation, and the court ruled that the functional nature of an organization and not a profit motive or a government ownership determine if it's an industry. After this case, a new definition of industry came into existence. The Honorable Supreme Court looked at this case and they made a big decision. They said the Bangalore Water Supply was a industry. And the court said that what matter is in the work being done, not who is doing it. They said it doesn't matter if an organization make an profit or not. If it's work like a business with the group of people working together to provide services, then it should be treated like one under the law. And it's introduced the triple test. To make this clear, the court created a simple 3 test. To be an industry, an activity must have organized work. The work is planned and done in a set way. Teamwork. It involves the people working together, employees and their boss. A useful outcome. It creates a product or a service that people need it. So the triple test, an activity is an industry if it's involved a systematic activity, cooperation between the employer and employee, production or a distribution of goods and services to satisfy the human wants, PDS system basically. And the main activity test, what about the group that they do many different things? The court created another rule called the main activity test, the dominant nature test. For organization with mixed activity, some industrial, some non-industrial, the entire entity should be classified based on the dominant or the primary activity. So thanks for watching guys. If you found this video helpful, so don't forget to like, share and subscribe. Okay, see you in the next video. Bye bye guys.